My name is Ravi. I'm from Armchair Criminal, and I welcome you all to this part of the program. This is the fourth part of a four-part series on res gestae. Therefore, it will be the concluding part. You would recall that res gestae is the fourth rule in section 118, which allows res gestae to be adduced. In this part of the program, primarily we will consider four topics: the intention of the maker of the statement, any comments made by the defendant, how that is being treated in courts. Thirdly, can res gestae be a substitute for calling live evidence? Fourthly, is there a need for the court to consider the interest of justice concept in admitting res gestae? You would recall that we considered cases like Stuart Barnaby, where there was a domestic violence and the complainant made a call in a hysterical condition. The police arrived, and how they saw the complainant in the state that she was in, and later not giving evidence at trial. Then equally, you might recall that we considered the case of Edwards. This is the case where the victim of a murder case, that was the wife of the defendant, visited one of her neighbors and told them that she feels insecure when certain items are at home, certain weapons, and how her husband behaves with that. Then that was allowed to be adduced as to her state of mind and the fear that she had at the material time. Just as in the case of Stuart Barnaby, where the officer was allowed to give evidence, call the 999 call as part of the evidence to show her emotional state as evidence in the case. Then you compare those cases with the case of Neil and North Antrim justices, where two boys witnessed an incident, gave information to the police. When the police attended the house to get the boys to give evidence in court, the mother said they are too frightened to give evidence. There the court disallowed the evidence from the boys to be adduced because how they were feeling, the issue of fear, did not come from the boys but came from the mother. Now, developing from that, I pose the question, how does the concept of intention operate? I have cited the case of Buckland, Mogul, Glassland, and Subramanian. Buckley is a case where a police officer had told his inspector that he is going to keep observation of a particular house because he feared that the occupant of the house is responsible for certain theft offences. Then the officer was found with stab wounds, having died from those wounds. The inspector was allowed to give evidence of what the police officer had said to show his intention that he was going to go and keep observation of the defendant's house. So there you have a situation where a previous statement from an unavailable witness being adduced to show an intention as to what was going to take place. Then the case of Mughal is a murder case, if I recall correctly, where a married woman had a lover. That relationship came to an end. Then she formed another relationship with a new lover. All this time, it appeared that the husband has been tolerant. She had made comments at her parents' house that she would kill the previous lover. Indeed, that man was killed, and the Crown's case was, it is the new lover and this woman is responsible for the death and no one else. Therefore, there were three options. Either the woman on her own was responsible, either the new lover is responsible on his own, or both of them were responsible. They were both arrested, charged, and joint. In fact, it was a joint charge. However, right at the outset, the defense counsel wanted to make a severance application because there had been a psychiatric report prepared concerning the state of the mind of the woman. The learned judge granted the defense application on behalf of the woman defendant, and the co-defense counsel really didn't make an objection. The female defendant's trial proceeded, and she was found not guilty. Now there was a problem for the counsel for the second defendant, the male defendant, because the prosecution failed to call that woman to give evidence or to tender her or to allow the recording of that conversation where she had said that she would kill her ex-lover to be adduced as evidence. However, the Crown gave several Section 10 formal admissions during the trial of the male defendant. He was convicted and he appealed. The Court of Appeal rejected his submissions, saying that yes, it is unfortunate that the indictment was severed where there are co-defendants. Severance should take place very sparingly But here it has happened, which is unfortunate, but that is where we are. And the Court of Appeal said that it is unlikely that this court would have ordered separate trials, but would not criticize the learned judge's decision. Then accepted that if there had been a joint trial, the tape recording would have been admissible to determine the issue of the mental state of the woman prior to the killing took place. The Court of Appeal said that looking at all the evidence, in particular, this defendant, the male defendant that is, had all the opportunity to blame everything on the woman. And he did during the course of the trial, despite the fact that the tape recording was never played. But equally, if I recall correctly, it was not the judge who excluded it. It was simply not done. So therefore his conviction remained safe. However, in the case of Blasland, Lord Bridge expressed his doubts as to the correctness of this authority. And Blasland is a case where equally another murder had taken place, and the defendant was charged with the murder and buggery of a 12-year-old boy, if I recall correctly it was. His case was that, yes, I do have homosexual relationship with adult men, but not with children. Yes, on the day in question, I was misbehaving. I saw a man called Mark, that he said, and I got frightened, thinking that he had seen me. I didn't bugger the boy because he was in pain. I left the scene. Then the following morning, the news was that the boy had died. The death of the boy had nothing to do with me. It must have been Mark, because Mark had talked to other villagers of the boy being dead, and that was before the recovery of the body. Therefore, him to have known that the boy had died implies that he must have been the murderer. He wanted to adduce that as part of his defense case, but that was not allowed. And the court said, basically, that it is a question of degree of relevance is there, but that degree depends on the facts of the case. And in order to prove the state of knowledge of the person speaking those words, i.e. Mark, here the defendant is trying to insinuate and draw inferences that it was Mark who must have killed the boy. Therefore, those words from the villagers remains hearsay. And here the issue is not that the court didn't feel that it has crossed sufficiently well enough to show that there is a direct causal connection between what the defendant says that Mark's supposed to have said and what has taken place here. And the court distinguished this case from that of the case of Rattan. You would recall Rattan is a case where there had been a phone call to the police from a woman who was in a hysterical state, and the defense case was that the firearm went off accidentally, and the court allowed the woman's statement to be adduced as to what was happening at the material time when she was ringing the police to show her intentions, the fears, the emotions. Therefore, the court found that in the case of Blasland, the conviction was safe and there was nothing wrong in refusing to adduce the evidence which the court said that it was hearsay. Now compare that with the following case, that is DPP and Subramanian. DPP and Subramanian was decided by the Privy Council. It is a case from Malaysia. The allegation was possession of firearm. The defendant was tried and he was convicted by the judge sitting with adjudicators. His defense was basically, I was kidnapped by some Chinese bandits. I was taken to the jungle. I was kept there at least for a month. They threatened me, saying that if I don't keep the firearms, the ammunitions, that they will kill me. Eventually they freed me to collect food. And I was going to surrender to the police. But before that, the police apprehended me. This was not allowed to be adduced in evidence by the trial judge. Therefore, he was convicted. And the Privy Council said that was wrong. It should have been allowed because it demonstrates Mr. Subramanian's state of mind. It is irrelevant, the Court of Appeal said, whether the Chinese bandits were serious when they threatened this defendant with violence and death. It is not that what matters. What matters is the state of the mind of this man, Mr. Subramanian, how he reacted. Therefore, the appeal was allowed. And now you would understand when one pleads, say in modern slavery or in duress, that there has been coercion in the case of Section 45 modern slavery defense, recruited, coerced, put in fear, and forced to do what the defendant is alleged to have done. That is why in modern slavery cases, such people are regarded and introduced as victims, because that is what they are. They may have sold drugs or whatever, but they are doing it not because they are voluntarily joining, but because of fear, because they are being used, they are being trafficked. So because of that, what the court is looking at is the fear, the perception of the defendant. Now, the next case that I would consider is the case of calendar. In order to do that, I ask myself the question, how does the statement made by the defendants are dealt with? There's a very good analysis of this case in the authority, and I have the authority here. This is in the Criminal Law Review. The facts of this case was that Calendar was arrested with two others. He was an animal activist, and the prosecution case is that he had material which could cause an arson. His two co-defendants case was that yes, we did have this material, but Calendar said they are of no use, they will not ignite. The whole thing is basically put fear, a show, bravado. And Calendar didn't answer questions in the interview, neither did he give evidence at trial. His both co-defendants were found not guilty, and he was found guilty. If I recall correctly, it was Lord Wilberforce in the case of Pratham, I think, said that there's a single test in order to decide whether to admit hearsay evidence. And that is basically, was there room for concoction and distortion? Now one might consider and ask, how on earth two defendants, the co-two defendants, was acquitted and this man was convicted, when the court was told by the co-defendants that this is what Calendar has told us. I myself considered the situation, and I think I can understand why the court came to that conclusion in applying the case of Rattan and Andrews. The two co-defendants' state of mind was based on what they say Rattan told, what Calendar told them. So that was the operative thing in the mind. Whereas Calendar cannot plead the same thing, because he was not told by anybody, by King Subramanian or his two co-defendants. He is saying this, if that is true. And it would have been a self-serving statement. That's one of the problems for you. Yes, that there's a self-serving statement in that, so therefore it wouldn't carry weight, and it doesn't come within his intentions or feelings, fears of that nature. In the light of that, the court found that Calendar's conviction was correct and refused to interfere with the judgment and the verdict of the court. Next, I'm going to consider the issue of, can the statement be used to substitute the evidence from a witness? In other words, live evidence. When I talk about a statement here, I don't necessarily mean a Section 9 statement. I mean any statement, be it a call to the 999 emergency services or having a chat with the police officer and narrating the problem to the officer. This is a tricky question for some practitioners in the magistrate's court. It is almost like the $50 million question, because there's one magistrate's court who takes the view that if there is res gestae evidence, that is all that is needed, that they can dispense with live evidence. If that is being suggested to the court by the Crown or by anybody, please waive the authorities of Andrews, compare that with Ibrahim, and refer to the case of Toby and Nichols, which I will consider in due course. I have the authorities here, that's what I was trying to find. Then also refer to Article 6.3 of the Human Rights Act, right to a fair trial, and our criminal procedure is based on an adversarial system where the defendant has the right to challenge his or her accuser. In the case of Andrews, Lord Old was quite clear that res gestae cannot be a substitute for calling the witnesses to give evidence. In fact, I have the authority here, and this is what Lord Old said. If you were to go to the penultimate paragraph of that judgment, there's a sentence which says, I would, and it reads as follows. I would, however, strongly deprecate any attempt in criminal prosecution to use the doctrine, that is a res gestae, as a device to avoid calling when he is available, namely the witness, the maker of the statement. Thus to deprive the defense of the opportunity to cross-examine him would not be consistent with the fundamental duty of the prosecution to place all the relevant material facts before the court as to ensure that justice is done. So you cannot have any more clear indication than that. It is incumbent upon the prosecution to call the witness. Res gestae cannot be a vehicle to circumvent of having to call the witness. That's another thing. Res gestae doctrine actually is not an exception to the hearsay rule. It is, again, this is from the judgment on page 4, second paragraph. Within small one, it says the res gestae doctrine is not an exception to the hearsay rule at all. It is simply a recognition that the acts constituting the event may include words. If those words are legally probative, they may be proved, but it is sought to tender such words as proof of truth. Of their content, they are not admissible in evidence. That's the whole purpose of it, isn't it? Yes, res gestae can be admitted to prove certain things, but that should be subject to the opportunity to be cross-examined, test the evidence. That can only be adduced if there's a probative value to the case, but not necessarily to prove the truth of its content, because it is not an exception to the hearsay rule. However, if the prosecution do want to, then they have to follow the normal rules of evidence in order to adduce that, which we can look at in a minute. Therefore, it is quite important for the court to understand, for the defense counsel to understand, the prosecution to understand. You cannot just simply override the defendant's right to challenge his accuser, because if that is done, there's a great injustice. However, you look at cases like Stuart Barnaby and Ibrahim. Ibrahim is a case where there was domestic violence. The wife called the police in a hysterical condition. I think the police came within about space of 10 minutes, only to find out that she's in a hysterical condition. There was bruising to her face. The bruising was developing as the police officer was speaking to her. The house was in a disarray. Then she received a call from her mother to remind her what could be the consequences for her from her husband if he comes to know that she has cooperated with the police. She refused to give a statement. Needless to say, she didn't come to give evidence. There, the learned judge evaluated the entire piece of evidence. The phone call to the police in a hysterical condition, the police attending and witnessing bruising and injuries to her. Still, she is in a condition of complete hysteria. The house was in disarray. Having considered that, the judge was satisfied that he could rule out the possibility of concoction or distortion and allow that to be adduced. Now, if you want to adduce such evidence where the defendant is contesting the case, you need to make an application under section 116. Although, if you are applying the principle of res gestae, then you don't need leave from the court. Remember, their res gestae is being adduced because the party relying on it is saying this is probative value. In the case, this is not hearsay. That is why you don't need the judge's permission. But where the witness doesn't come to court, the prosecution wants to rely on that, then the whole thing is different. Because when the res gestae is being adduced and the witness is there, what is being adduced is not hearsay evidence. It is as probative evidence in the case. Whereas, where the witness is not at court to give evidence, it is hearsay evidence. Yes, it might have a probative value, I accept that. But the witness is not there to testify it. Remember the concept of that, the witness giving an oral evidence in the proceedings. Go back to section 114 and 115 to see how it works. So therefore, in that situation, there should be an application under 116 or 117 or 114 in the interest of justice. One of those needs to be played around with. That is important to understand. That is why, in the case of Ibrahim, the court didn't find anything wrong with that. I'm not going to look at Morgan because it's pretty much is the same. Next question that I would pose is there an obligation to consider the interest of justice factors when one relies on res gestae? The answer is no. Think logically. Law told, in the case of Andrews, says res gestae is not hearsay evidence. It is admitted because it has a probative value in the case. That's what it is. So you don't need to consider the interest of justice criteria. There you adduce the res gestae as any other piece of evidence, be it forensics, fingerprints or whatever. If there's a probative value, you adduce it. That is important to understand. And next question that I would pose is there a need to serve notice to adduce res gestae? Criminal Procedure Rules 34 deals with this particular issue. Technically, you don't need to give any notice to the court or to your opponent. You can adduce it. But I wouldn't. Because if you go down that road and you get it wrong, I don't think the judge will be particularly pleased. So it is better to tell the court that you intend to adduce this piece of evidence. And remember, end of the day, the learned judge has to be satisfied that the material is res gestae. It is a legal issue. It is the judge who decides it. So, although that there is no such obligation, in my view, it would be prudent to alert the court, your opponent, and raise it in the absence of the jury or with the justices at a pre-trial review, if you can. My next question is, what is the procedure for applying the rule? As I said, if it is res gestae, you don't have to give any notice, you can do it. But I wouldn't. I would recommend that you raise it with the judge and follow it through. But where the witness is unavailable and there is res gestae evidence that you want to adduce, as I said earlier, follow section 116 criteria and go from that. It may very well be that section 116 is the most applicable, I would have thought. Unlikely section 117. Possibly as a buffer, apply the safety valve in section 114. The next case that I would consider is Toby and Nichols. And I said, if the court were to say that we have res gestae, we don't need to call any other witnesses, I said, please waive Andrews. And this is one of the cases that I would like you to remember and cite. Here the facts are quite simple. There was a collision. The collision was between a coach and a Mercedes-Benz car. The Mercedes-Benz didn't stop and left the scene of the accident. The police arrived, and with the police, the coach driver attended the defendant's house, only to find out that there is a Mercedes car parked in the forecourt of the house with damages around the relevant area, which looks pretty new, consistent with what the coach driver has told the police officer. Knocked on the door, the defendant opened the door, and the police officer immediately noticed that he was under the influence of alcohol. The allegation was put, and the coach driver said, "This is the guy," identifying the defendant. The defendant reacted by saying, "This is all load of rubbish. I was not driving. In fact, it was my wife." Bless the heart of the wife, who said, "Don't make things worse. I was not driving." He was taken to the police station, and the wife attended the police station. The drink drive machine was out of order. Therefore, blood sample was taken, and under section 10 of the Road Traffic Act, there's a duty on the police to provide the results at least 7 days before the trial, which was never done. It was served on the day of the trial. More importantly, the coach driver didn't attend court because he was never warned. The defense counsel, under pressure, decided to accept the results of the drink drive procedure, which really contravenes what is said in the legislation. And the prosecution relied on what the coach driver had said. The defendant didn't give evidence, and he was convicted. He appealed, and the court said, never mind whether the learned defense counsel had the authority to waive a statutory right the defendant had, but more to the point, here the coach driver did not come because he was never warned to come. Therefore, it was wrong to have admitted that piece of evidence. And in fact, if I recall correctly, the court also said that the defense counsel didn't have the authority to accept against what is prescribed in section 10 of the Road Traffic Act. Therefore, the appeal was allowed. So you see the importance of asking the witnesses to attend. It is not a foregone conclusion, not by a long chalk, that if there is res gestae that is all needed, we can dispense with the attendance of witnesses. It's wrong. That is all I intend to say with regards to res gestae, and that brings us to the end of this 4-part series on res gestae. Therefore, you would note that res gestae is a very important and a useful tool to have, because it has the capability to introduce certain pieces of evidence which could otherwise be left out and causing injustice to the complainant, possibly the defendant, and the community at large. Equally, it has evolved and developed since the early days of when it first came to existence, like the days when the case of Bedingfield was decided. Equally, it is important to note res gestae evidence need not necessarily come from the complainant. It could come from another person. And there are circumstances where the immediate event is over, but has a continuing scenario where the complainant cannot make even the first complaint. Let's assume we had the pandemic, we were in lockdown, and no doubt you would have heard that domestic violence had gone through the roof. If there had been domestic violence, could the complainant really make a phone call and seek assistance or go elsewhere seeking refuge? No. Therefore, the complainant could be living under the same roof as the defendant, the suspect, in fear. So it could be a case where the time span is quite large. If you would recall, Stuart Barnaby, I think, is a classic example on the point. In my view, it is difficult, if not impossible, to define res gestae and how it could be dealt with. For my part, I look at the circumstances and what is at issue. Then I take a view. Is this really res gestae? If it is, how I can justify it to the court? If I take a different view in order to object, again I view and decide on the circumstances. I equally think that we have to work harder to dispel the belief that some Crown prosecutors have with regard to that res gestae is the only evidence that is needed, and that could be a substitute for calling live evidence. It is correct, as we have seen, that there are circumstances where it can be, but it is completely different to it being automatically allowed. If that were to be the case, there could be serious breaches of the defendant's human rights, and it would be wrong to deny that right to challenge the witness. It is correct that res gestae evidence need not ask to be adduced with the permission of the judge, but I would highly recommend that the issue is raised and put everybody on notice, deal with the issue of whether it is res gestae or not. Because if it is not res gestae, then it may very well have to be another application. But if it is res gestae, then at least the court and everyone knows how it is going to plan out. Because if that is not done, there could be only one remedy. The defense will be asked for a retrial. And I don't think that the court will be too pleased with that. That is all I intend to say. I hope that you have found this part of the program is useful and interesting. Thank you for your valuable time. God bless.